Welcome to this free immigration help channel. Today is April 4th, 2023 and we are getting into the volume 52 of me answering your questions. As you can see, I have all your comments pulled up over here. Before we begin, as always, I'm going to mention I am not an immigration attorney. This is not a legal advice. All the information that I provide on this channel in my videos are directly from official government sources like USCIS and of course the Department of State. So without further ado, let's start with the first question from Kevin Hunt. If I have left the country and I am trying to re-enter again without my green card, which I have not received, can I still use it to enter even if the visa time frame expired already? Okay, so Kevin asked a question on the video about the I-551 form, which is it's an immigrant visa that you receive, whether it's a family petition or employment-based petition. Once you complete and you're outside of the United States and you complete the whole process, you go through the interview, you get that I-551 in your passport, which is, yes, it is considered an immigrant visa before you enter the United States, but once you enter the United States through the port of entry and you get the stamp from the CBP, Customs and Border Protection, this I-551 automatically becomes a temporary permanent resident card. So that temporary permanent resident card, you can do really anything you would normally do with a regular green card. All right, you can travel back and forth, exit, exit the country, come back into the country without any problems. So, Kevin, I'm gonna ask you a follow-up question. With all of that being said, I understand this I-551 that you have is expired. All right, and technically, when you entered the country, you should have received, within 90 days, you should have received your permanent resident card, the actual card, right, the green card. And usually it is done within 90 days if all the fees are paid beforehand. So if you have, again, if you have an immigration, some kind of petition, whether it's family-based, employment-based, once you pay all of the fees, you get documentarily qualified. Part of that documentary qualification process is paying all of the fees, and sometimes in some cases you actually pay for the green card as well, and sometimes you don't. So I have a follow-up question for you. Has that fee been paid? Because if it has not been paid and your I-551 stamp already expired and you have not gotten your green card because you have not paid the fee, it means that you fail to maintain your immigrant status, which creates a situation. That's the worst case scenario. The best case scenario, you have not received your green card because some kind of mistake from USCIS, or maybe you moved and it was lost somewhere in the process. If that's the case, then it's really not a big deal. You can just apply for a replacement permanent resident card and get a replacement one. It's Form I-1. In fact, I'm going to use this as an opportunity to do some navigation. We're going to go to USCIS.gov website. Always check, whoever's watching this video, for everyone who's watching this video, always make sure that the websites that you're getting your information from is .gov websites. That's the government websites. So this is U.S. Citizenship and Immigration Services website. We're going to go to Forms. We're going to go to All Forms, and this will give us all the forms, petitions, applications. They're in numerical alphabetic order, so you can just scroll down to it, or you can type in the number of the form. In our case, it's 90, application to replace permanent resident card, and as you can see, you can file it online. So if your status of a legal permanent resident is good, all right, then all you need to do is just file the application online, pay the fee for the replacement, and the fee is pretty expensive fee. I've actually done a video on how to file a fee waiver. If you qualify for that, you can try doing that. And then you get your replacement permanent resident card and you're good. However, with all of that being said, again, going back to the possibility one, if that is the case, if you fail to maintain that permanent resident status, then I would highly recommend, as soon as possible, reaching out to an immigration attorney for a consultation. Find attorneys in your area that provide free consultation and do like 3, 4, 5 different consultations with different attorneys and see what they recommend, because the worst case scenario is a serious situation. You definitely don't want to be stuck in it without the status and basically risking everything in the future. So please do that, and if you can follow up with a comment, I would really appreciate it. Submit a separate comment, don't respond to this, submit a separate comment and explain your situation a little bit better if you want any kind of additional follow-up, but this is as far as from what you commented. This is so far what I can tell you. All right, let's move on to the next one from MK. C26 cannot file online. Okay, yes, this is for the employment authorization document. MK, thank you for letting us know. Yes, some of the categories, even if some forms are available to file online, some of the categories within those forms and applications, petitions, sometimes there is an exception where you cannot file it online and you have to file it physically with a paper, and that seems to be the case for the C26 category for the I-765 form, application for employment authorization document. The reason I think why USCIS does it is probably because they might need some kind of physical evidence sent with the application. Maybe that's why, but hopefully they will find a way to address and just make as much as possible to be available to file online, because it simplifies the process, it's cheaper, it's faster, and it protects from unnecessary mistakes, because there's a difference when if you type in the word on the keyboard, somebody who's reading that, they're not gonna make mistake unless you make a mistake on the keyboard, and unless that person is really not paying attention who's reading it, compared to printing. Sometimes my handwriting is horrible. So people make mistakes when they read my handwriting. All right, let's move on to the next one from Marcelo. Being outside of US as a permanent resident for 2 years for studying or medical temporary treatment. Can I get a re-enter without losing my green card? Thank you. Marcelo, thank you for your question and thank you for watching my videos. So with this situation, because it's not recommended. It's definitely not recommended to be outside of the United States as a permanent resident for a certain amount of time. Honestly, I don't recommend being over 1 year, but according to the USCIS, it's over 2 years. All right, so in USCIS eyes, you don't want to be outside of the United States with the legal permanent resident status over 2 years. Why? Because it shows them that maybe you're not really a permanent resident of the United States since you are living for 2 years somewhere else. All right, so it definitely makes sense. It's it's understandable. But in your situation, you do have a good reason, whether it's studying, whether it's medical temporary treatment. But regardless, you do want to apply for a re-entry permit. And again, I'm gonna go to the application to replace not the application to replace permanent resident this time, but we're gonna go to forms, all forms, and let me think which form that was. I believe it's definitely in I, not in G. Let's see. Nope. Petition for number. Nope. Petition for alien. Nope. Petition for alien relative. Application for travel. There you go. Application for travel document I-131. I believe within the application for travel document, we're gonna go and open up the form. Unfortunately, there is no way to file this form online. You will have to do it by mail. But we're gonna go into the application for travel document, and I am gonna check. There you go. I think this is it. I'm a permanent resident or conditional resident of the United States, and I'm applying for re-entry permit. That's it. That is it. So 1A right here, this is going to be your answer. So form I-131, take a look into that. Again, you have to understand that whenever it comes to the permanent resident status, right, whether you are outside of the United States for 6 months, for 1 year, for 2 years, permanent resident card, it shows your status in the United States, that you are a permanent resident. And when you're flying in, going through the port of entry, going through the customs and border protection, most likely they are not going to create any problems for you. They're not going to be like, ooh, we see that you've been outside of the United States for 1 year. Whoa. In very, very rare cases, unless there is another reason, another something more important for them to kind of catch on, and then they start digging and then they start asking you all of these questions. Usually that does not happen. Problems like this typically do not happen. Nevertheless, it's always best to play whenever it comes to whether it's CBP, whether it's USCIS, whether it's NVC, whoever it is that you're dealing with. It's always best to play as safe as possible and have all of these different layers of protection. And the re-entry permit is one of those layers of protection. Again, it does not guarantee that you will 100% enter the United States and they don't cause you problems during the, conversation with this Customs and Border Protection officer, but you will have that extra layer of protection for yourself, for your peace of mind, and it's definitely good. It's definitely good. And also on top of all of that, the reason why I started talking about the CBP in general, even if the CBP does not create any problems further in your immigrant journey, right? Let's just say that when you are applying for your naturalization, during the naturalization interview, be prepared. They will definitely ask you, okay, so we see that you have been outside of the United States back in blah, blah, blah for a whole 2 years. Why? Why have you been living somewhere else? Do you not like it here in the United States of America? Do you not want to be a permanent resident? Or, just be prepared for questions like this. So again, having that re-entry permit, it shows that you actually care about your status, that you care about doing everything the right way, and you are showing the actual reasons now because you are applying for I-131 and you're already showing them why you were outside of the United States for so long. You're showing them that you actually do care about that status. Okay, so I'm gonna pause this. If you have any follow-up questions, do not hesitate to ask. All the questions, as many questions as you guys have, are very, very welcome. All right, let's move on to the next question from Sassy Diva. F11, I'm assuming that's F1, all right? F1 category, priority date February 2014, documentarily qualified August 22, Jamaica. How long before I can get interview date? Sassy Diva, thank you for your question. Let's take a look at the visa bulletin. I'm gonna close this page, and we're gonna go to home page here. All right, we got our visa bulletin for April 2023, which is the most recent visa bulletin, just recently came out, like a week ago. So let's scroll down. F1 category is unmarried sons and daughters of US citizens over 21 years old. I don't know, they still don't put that over 21. They should do it. Please do it. If you guys watching from Department of State, please do it. It's confusing for a lot of people. Okay, so priority 1 category, we're going to scroll down to the graph B, which is dates for filing, which is when you filed your petition initially. Priority date, basically. So let's take a look. Priority date is February 2014, F1 category. And looks like you are August 2016 right now. So all chargeability, Jamaica all chargeability. So looks like you are before what is listed right now on the visa bulletin. Now, don't let this worry you too much, because we know visa bulletin has not been updated for about a year and a half, like 22 months, I think, if I'm correct, almost 2 years. It has not been updated for all of the categories except for F2A just recently, just literally this month, as of April 2023, the F2A category finally updated, and we have the updated dates here for the F2A category. So all these other categories are like a year and a half, more than a year and a half behind. So if you combine August 2016 with that artificial backlog, that's what I like to call it, because it was caused by all the delays, not the delays, but basically stoppage of processing completely during the whole situation with the pandemic. So we had that extra year and a half, 2 years artificial backlog on top of the organic backlog, which is also technically not organic because it's Congress. They just limited the caps. But anyway, the point that I'm trying to say is that don't let this worry you, because it's kind of behind. But because you were already documentarily qualified in August 22, that tells me that they have been waiting close to the availability of the immigrant. So I think I can say with a 95% positivity that your immigrant visa is either already available or should be available anytime now, any moment now, or anytime around the corner. Now you have been waiting already about 6 months, and looks like, from at least from the comments, from people commenting and telling me about their interviews and when it's scheduled, looks like it's anywhere between 6 months to about a year and a half in very rare cases for that interview to be scheduled. So hopefully within the next 6 months you will have your interview scheduled as well. Here's the thing: because you are already documentarily qualified, all right, and because there is a high possibility chance that your immigrant visa is already available, at least judging by the visa bulletin, your immigrant visa is 100% should already be available, all right, because you're 2 years behind the priority date listed on the visa bulletin. I would recommend sending an expedited request with the NVC. I have made a separate video on how to do that. It's very simple. Basically, you're just sending the email with your information, requesting the expedited processing, and you will have to give them a reason why you're requesting this expedited processing. I mean, whenever it comes to immigrant, family reunification petitions, haven't been able to see your parent, because I mean, if you're a parent yourself, or maybe you're inviting your child, or maybe your child and your parent is inviting you to the United States, whatever whether you're the petitioner or beneficiary, still you've been waiting for that long, since 2014. I would say it's pretty emergency. Okay, 9 years you haven't been with your family. It's an important reason. So give it a shot. If it works, great. If it doesn't, in most of the cases, unfortunately, it doesn't work, but it's worth the shot. Maybe you will be able to speed up that interview process a little bit faster. But regardless, whatever you decide to do, I would not worry about anything. The only thing right now for you is just to have some patience and wait for the interview to be scheduled, because it should be somewhere right around the corner. Okay, let's move on. We got a comment from Sirgut. The only reason why I know the name is because Sirgut told me. Thank you, Sirgut. Appreciate it. Good explanation. Thank you, brother. Have a nice day. Thank you, Sirgut. It means a lot. I wish all the best for those of you who are asking in the comments. All right, let's move on to the next comment from Ali Rana. Dear, you're a very good person. Thank you very much, Ali. I appreciate it. I'm not really that good, but I appreciate it. It means a lot. I'm glad this stuff is helpful. All right, let's move on to the next question. Comment from Jones CCW. Hi, sir. Please answer, when will I have my interview, as follows. All right, Hong Kong, chargeability area so F4 category, priority date July 2007, March 2021. Thanks. Okay, Jones, I'm gonna ask you a question, and I'm sorry, I don't mean to appear, ignorant, but Hong Kong, is that considered to be in China chargeability category, or is it in the all chargeability category? Because between China and all chargeability, there's a pretty, well, actually, which category is it? F4. Let's see how much of a difference. Maybe there isn't really any difference. Let's take a look before I even ask that. No, looks like it's exactly the same. China and all chargeability. Doesn't matter. Never mind my question. So looks like it's exactly the same for China and all chargeability. So whichever Hong Kong falls in. But honestly, if you let me know, that would be still very nice, because it would be for my personal, so that I know whether Hong Kong falls in all chargeability or is it falls within China chargeability area. Okay, so you have F4, which is brothers and sisters of adult US citizens, which is the forced priority category, which unfortunately takes the longest compared to everything else that is out there. So your priority date is in 2007, so that's when the initial petition, I-130 petition, was filed. So 2007 July, and according to the visa bulletin, we have December 2007. All right, so you are right around the corner, and you are already documentarily qualified as of 2021. I think the only reason why you are still waiting for that interview is because of that artificial backlog that I've been mentioning earlier in this video. Basically, that was created by the delays because of the whole pandemic closures. Because when, I don't remember exactly when, but whenever this whole stuff started escalating and getting out of control, NVC, the National Visa Center, they completely stopped processing everything. They placed everything on hold. All the U.S. embassies around the world, they stopped taking the interviews. They stopped. I think the only thing that they had working was for U.S. citizens that are outside of the United States, so that they can get services from the U.S. embassies around the world. But for immigrants, non-immigrants, all the visa services were completely shut down, and it was quite a long time. I can't tell you exactly for how long, but it appears to be like about, man. Well, we do have the artificial backlog of about year and a half. All right, in some situations about 2 years. So I guess it depends on which of the services they started basically processing first before they opened up everything else. And I'm pretty sure they started processing the immigrant visas first before they started processing non-immigrant visas. I think, again, I don't remember exactly, but with that being said, since you are already documentarily qualified, it means that the immigrant visa is somewhere around the corner. It's either already available or should be available anytime now. Now, with that being said, okay, because your priority date is in July 2007, and according to the current visa bulletin, I know these are not correct numbers. For everyone who's watching, we know that these are not the correct numbers. Because if these were the correct numbers, people like Jones, CCW would have had his interview already. People like Sassy Diva, they would have had already their interview scheduled. We know these are not correct numbers. However, you gotta use this as an opportunity for your advantage. Because these are not the correct numbers, they're still on the visa bulletin. And because they're still on the visa bulletin, it gives you the right to file that expedited request with the NVC, saying that, look, on the visa bulletin, it says that right now the immigrant visas are becoming available for people that have filed their I-130 petition back in December 2007. I filed my petition back in July 2007. So my immigrant visa is supposed to be already available according to your own source, your own information. That's what you're technically telling to NVC. Look at your own visa bulletin that you provide. You told me that my immigrant visa is supposed to be already available. I am already documentarily qualified. I still haven't had my interview scheduled since already 2021. I want my case to be expedited because, and give them a good reason. And again, with the family reunification petitions, all of them have a good reason to be expedited. All of them. All of them are emergency. All of these petitions are an emergency because we are talking about the family. Whenever you separate the family, it's an emergency. You can't have the family all over the world, just, in random places, especially the families like people who are filing these petitions that are doing everything the right way, and they're waiting for years and years, since 2007. Think about this. Jones been waiting since 2007. 16 years? That's a long time to wait. I would say that is a pretty emergency situation here. So Jones, with everything that I said, don't worry. Just I wish you some patience. Your interview should be coming anywhere, between, like I said, to Sassy Diva above. In her comment, I'm assuming that's her, female. Like I said, it's between 6 months to a year and a half. It really depends on the category, but that's not the important part. The important part that everything is already done, and it's really just a matter of time, some patience, and once the interview is scheduled, you're good to go. But with all of that being said, if you can submit your NVC expedited request, and if it is expedited, good for you. You're not losing anything. Just be, of course, very polite, very professional in your expedited request. Give them a good reason, which you do have a good reason, and see if it works, it works. If it doesn't work, well, that's fine, but at least you try. You use their own source of information basically to give you an opportunity to submit that expedited request. All right, let's move on to the next comment from Simone Williams. Hello, hope you are doing well. Have a follow-up question. I have received the notice of immigrant visa case creation letter with my case and invoice numbers for a while now. Okay, great, but I wasn't asked to pay any fees or send and documents. It only tells me to keep it in a safe place as I would need the information to log in with CAC. Is that a bad thing? As I told you in one of my messages before, my priority date is June 2017. Simone, I don't think that's a bad thing at all. So if I remember correctly, you said you can actually go and log in to the CAC, to the NVC portal, and there's just nothing. It allows you to log in, and there's nothing that you can do there. You can't pay any forms, can't submit any documents. It's not bad at all. It means basically that they are waiting closer to the availability of the immigrant visa for your case. And that's why they are not allowing you to become documentarily qualified. I think as of recently they started doing this. I think earlier, probably a couple of years, few years earlier, they would just allow everyone to get documentarily qualified even way before the immigrant visa became available. Now they are waiting closer to the availability of the immigrant visa, which can be a little bit annoying, I understand, because now you're kind of, in the dark, just waiting and not knowing when it's going to happen, and you can't, you could have used that time in order to submit all the documents, pay all the fees, all right, become documentarily qualified. But instead, you have to wait. It's annoying, yes. But on the plus side, once you get the full access to the portal, where everything is available, where you can submit the documents, where you can pay the fees, now you can tell for sure that the immigrant visa availability is right around the corner. They waited closer to the availability of the immigrant visa. So yes, it's annoying to wait, but at the same time, you will have kind of more assurance once you have the full access to the portal that the immigrant visa is becoming available soon. So what I would recommend you to do, don't worry, just once in a while, don't wait for them to send you some kind of correspondence, twice a month, maybe once a week, log into that CAC portal, the NVC portal, and see if there is anything new there. Just keep your eye on it. But other than that, it really comes down to just being patient. All right, moving on to the next one from Aman Sandi. Hello, sir. Hello, Aman. Appreciate you being publicly subscribed to this channel. Means a lot. Thank you. Moving further, we got, okay, Jones already answered your question. You know what? I'm going to post this because I will forget. Right, responded. Thumbs up to Aman, and we're going to move on. Jones already answered. And then we got Pape. Let's see what, all right. Pape Mbisan Doof. Probably mispronounced it. I'm very sorry, Pape. But I'll try my best to answer your question, better than pronouncing your name. All right. Hi, my friend. Thank you for your answer yesterday. You're very welcome, Pape. Thank you for asking your question. This is Pape Bisandouf. I have two questions. First question. I'm a permanent resident who applied for my spouse. Okay, so F2A. And my case is documentarily qualified. Congratulations. For an interview on April 15, 2022. Congratulations. That's great. A US citizen applied for his spouse, and his case is also documentarily qualified for an interview on September 2022. Is this possible the US citizen's spouse get an interview letter before my spouse? Yes, absolutely 100% is possible, Pape. Why? Because you are still in the F2A category, which is... okay, so F2A... And I know some people probably might have gotten a little bit confused from what I've been talking about the F2A. F2A used to be always current, okay? Yes, there is a cap on technically there is a cap. If you look at the visa bulletin, there is a cap on the visa category. However, because that cap is, I would say, was an acceptable cap, unlike any other category that is here. Even the F1, which is the first priority, the kids over 21 of US citizens. Still, F2A had much better, much faster processing and stayed current. Why? Because there was a better overall cap, and also there was an exception. There was an exception, 75, not exception, sorry, exemption for the worldwide family preference visas category, right? So, with that being said, if you look at the priority date graph on the visa bulletin, you will see that the F2A in the priority date, it still shows current, which now we know that this is fake news, unfortunately, because the documentarily qualified graph, graph A, has been updated, the only category that updated as of April 2023. Now we see that there is a backlog of about 2.5 years, depending on which chargeability. For Mexico, it's more than that, way more than that, unfortunately, for the F2A category. So that directly kind of replies to your question and in your comment. When US citizen petitions for spouse, there is no visa cap whatsoever. Yes, the delays in the processing, they will affect. Yes, whenever it comes to, getting documentarily qualified, there will be some time waiting. Yes, scheduling the interview, them transferring to the embassy, all of that will take time. However, they are not affected at all whenever it comes to the visa availability. Unfortunately, F2A does. They are affected by the visa availability, by the visa cap. So yes, I would be surprised, honestly, if permanent resident petition got, the notification for the interview same time, if they were, documentarily qualified same time as US citizen petition. Okay, let's read your next question. My second question, do I need to depend on the visa bulletin once my case is documentarily qualified for an interview? Yes, Papi, absolutely. I wouldn't say necessarily depend, but checking it every month, it would be very helpful. I will make every month the new visa bulletin comes up. I've been talking too much already, 30 minutes non-stop talking. Every month the new visa bulletin come up. I will make a dedicated video for it where I compare the dates, right now and with the previous visa bulletins, see what changed and see how the backlog looks so far. But yes, definitely for you, if you look at the F2A category at documentarily qualified dates, it shows you that there is about 2.5 years right now of that backlog. I wouldn't 100% rely and say, okay, so 2.5 years, it means from now on, I will wait 2.5 years for the interview to be scheduled. Because this 2.5 years, because the F2A used to be current, I think that within the next 6 months, maybe a year, we will catch up and F2A will become current again. Don't take my word for it. That's just my kind of prediction of the way things used to be, and now finally we're all open after this whole pandemic situation that created all of this. It created a mess, honestly. It created a big mess, unfortunately, for a lot of people, a lot of immigrants. Legal immigrants have been affected by this closures that somebody thought was a good idea whenever it comes to immigrant visa petitions. Because, I understand you want to prevent the spread of the flu and all of that stuff, okay? I understand that. And you're scared of getting sick. I understand that. What I don't understand is the people who've been waiting from 2007, right? Why are they should be affected? Why the immigrant visa availability should be affecting them? They were waiting for years, and they will keep waiting for years. Why stop basically the clock for them? But again, that's the way the backlog works. Because they stopped processing current immigrant visas, it added on top of the previous one. So again, that is all understandable, but nevertheless, it's really sad and unfortunate. So we will see. Hopefully in the next few months, with the new visa bulletins, we will see some updates, and we will have a little bit of a better picture. At least better as F2A category. That, you know, at least now we know what's going on. So thank you everyone for watching. Thank you everyone for your questions. If you have any follow-up questions, don't hesitate to ask them. Just make sure to submit them in a separate comment, because if you respond to my comment within your comment, I don't see, for whatever reason, I don't see the answers to that. YouTube does not send me the notification. But thank you very much for watching. Thank you for your time. God bless, and I'll see you in the next video.